Good evening. Good evening, and welcome to this session on corporate laws and economic laws. The last session, we began our discussions on operation and mismanagement. We went through the basic sections basic section 241, which dealt with application for operation or mismanagement. In fact, we saw operation and then we saw mismanagement. Then we saw the requisite number of members having the right to apply under section 241. This is contained in section 244. Since it's quite important, let me once again take you through this portion, then maybe one or two more practical problems, and then move on with the topic. So basically, in the case of a company having share capital, the application under 241 can be made by not less than 100 members of the company or not less than 1/10 of the total number of its members, whichever is less. So either 100 members or 1/10 of the total number of members, whichever is less, not less. Or as an alternative, any member or members holding not less than 1/10 of the issued share capital of the company. So we also discussed why issued share capital. I gave you a long-winded story about the first domestic airline and all that. And I showed you how one of the complaints of operation could be that the shares issued by the company and applied for by the complainants is not allotted. So they have the proof of payment of money and the application is also there, but the board of directors or the controlling group has not allotted the share. So they show that they may not be holders of subscribed or paid up capital, but they are holding issued capital. So this is a very peculiar section. One of the only section, I would say, not even one of the only, no, possibly now I should say one of the, because earlier this was the only section which spoke about issued share capital. Now it is one of the two. 244, you will find that 245 also talks about similar provision. So in the case of a company not having share capital, not less than 1/5 of the total number of its members. So the applicant or applicants should have paid all calls and other sums due on his or their shares. So that is one thing. And joint shareholders should be taken as one member, right? Usually there is a big issue as to whether a joint shareholder will be two members or one member. If nothing is mentioned, then each of the joint shareholders is a member. If nothing is mentioned, the section is silent or the rule is silent, then if there are two joint shareholders, they will be considered as two members and not as one member. But here they very specifically say joint shareholders shall be taken as one member for the purpose of counting the number of members. Now, suppose the number of members is not up to this mark, then they may make an application to the tribunal mentioning that though they are not sufficient in number, the matter is important. Then the tribunal may waive these requirements and enable the members to apply under section 241. But that is at the discretion of the tribunal and not it's not a right. It's up to the tribunal to either provide this facility or not. So we saw many practical problems. Now, I think we didn't cover this. One sec. I don't think we covered this. So let me quickly go through this in case one or two more. You'll notice that maximum number of questions have come from the old 399, which is your new 244. A group of shareholders consisting of 25 members decides to file a petition before the company law board for relief against operation and mismanagement by the board of directors of Messrs. Fly-by-night operators. One really doesn't understand how, with a name like that, how did they become members? Fly-by-night operators. The company has a total of 300 members, and the group of 25 members holds 1/10 of the total paid up share capital, accounting for 1/15 of the issued share capital. So, first of all, advise the group of shareholders regarding the success of getting the petition admitted. Okay, then we will see their complaint. Now, actually, the rule is 100 members or 1/10 of the total number of members, whichever is less. So 300 members, which means 1/10 of 300 is 30. So this group does not hold even 30. They are 25 members. They are not 100. They are less than 1/10 of 300, 30. At least if you come to the issued share capital, see, they are holding 1/10 of the paid up share capital. But they are holding 1/15 of the issued capital, which is 1/15 is less than 1/10. Okay, 1/15 is less than 1/10. Therefore, they are holding less than 1/10 of the issued capital. It is quite possible. Don't think it's an anomaly, because the issued capital will be larger than the paid up capital. So it is quite possible for somebody to hold 1/10 of the paid up capital and 1/15 of the issued capital, right? So this being the case, you see, they are holding less. This is the whole point, right? So they have not been allotted shares. Okay, so they are holding only 1/15 of the issued capital. So they are unable to apply for relief. So they are not statutorily eligible. Okay, but to make an application to the tribunal, not CLB, for relief. But you will appreciate that by virtue of section 244, that which we saw now, tribunal may authorize the members to make the application, provided it is satisfied that it is just and equitable so to do. So the members are advised to approach the tribunal in this regard. That way, you need not say, see, if you close this answer by saying, if you argue correctly and you say they are not eligible, you are right. But you shouldn't stop there. You should also advise, because the question says advise the group of shareholders. So you should also say, look here, you are not eligible to apply. But if you want, go to the CLB or to the tribunal on an application for permitting you to apply, even though you are not having the requisite number. So once you do that, they may be able to get the tribunal's approval, in which case there should not be any problem, right? Now, coming to the next, in the same problem you have, the main grievance of the group is that due to mismanagement by the board of directors, the company is incurring losses and the company has not declared any dividends, even when profits were available in the past years. Now, first of all, even assuming that they have the requisite number, will they succeed in their application for mismanagement? The answer is no, because merely incurring losses is not mismanagement. Nobody says incurring losses is a good thing, but mismanagement is something totally different. See, due to trade cycles or due to some other unforeseen circumstances, a company may be incurring losses. But even assuming that the board of directors is inefficient, inefficiency is not mismanagement. There should be something that they are doing which is prejudicing the interest of the company. Okay, it's a very thin line, right? So merely incurring losses is not enough, right? So there should be some kind of a intention to prejudice the interest of the company. Some fraudulent activity, something that is something by which the majority group is doing something to the prejudice or to the shall we say, to the detriment of the minority group. Unless they show that there is something like that, then otherwise they show that it's not. Similarly, not declaring any dividend is no way it's a mismanagement, because dividend is a board decision. If the board of directors does not want to declare a dividend, they need not declare. Members cannot declare a dividend. It is the board, members cannot propose the dividend. It is the board, based on its own understanding of what is needed, what is what. It's a board decision. The board recommends the dividend, and the members may approve the dividend recommended or a lower amount, percentage. They cannot declare a higher percentage than the percentage declared by the board. So this being the case, it's absolutely clear that the board of directors, there is no mismanagement even if the petition is admitted by the tribunal. This is another beautiful example, but be very, very careful here. A group of shareholders of Badwill Machineries Limited filed an application before the CLB. See, these are all old questions. Just wherever you find CLB, please read Tribunal. Alleging various acts of fraud and mismanagement by Mr. Big Fish, the MD of or his associates. Okay, so mismanagement by Big Fish, the MD or his associates. Now, during the course of hearing before the CLB or the tribunal, the authorized representative of the said company contended that the alleged transactions had taken place several years ago, and the company has already removed the managing director who was responsible for such transactions, and hence there is no case before the tribunal to interfere in the working of the company. Now, the applicants have submitted that although the fraudulent transactions were done in the past and the MD has been removed, the company is still controlled by the persons who are in league with the MD and are working as his henchmen. Now, whether the complaint made by the applicants would succeed is the question. Let us see. Give me 1 minute. I'm just logging on again through the query pad. Good evening. Okay, so Sumit is here. Thank you. Now, what I suggest, why don't you give your answer quickly? Some of you who have just joined, give your answers on the query pad. See, they have filed for mismanagement. Now, if you go through the provisions of mismanagement, mismanagement talks about future. Mismanagement does not talk about the past, right? It only talks about the future, okay? Whereas oppression talks about both past and present. Oppression does not talk about future. 241(1)(a), you can see that on the top of the slide, deals with oppression. 241(1)(a) uses the words have been or are being. So past and present, okay, for oppression. But for mismanagement, it is by reason of such change, it is likely that. So the future is only indicated here. Past acts cannot be considered. So although in the past, Mr. Big Fish has done certain things, he has been removed. And for a past act, you cannot invoke the provisions of 241(1)(b). You should show that there is something which is going to happen, change. Because of that change, it is likely that the affairs of the company will be conducted in a manner prejudicial to the company or to the interest of the members. Unless you are able to show this, then there is no mismanagement. Once again, I'll show the slide for your ready benefit. So here it talks about interest of the company or members or class of them. Whereas oppression, public interest is also involved. So actually, as I told you, these are two separate concepts, 241 1A and 241 1B, which have been unnecessarily, according to me, clubbed together in one section. They could have as well had two different sections for it, with 244 being some sort of a common link for all of them. That's like, in the old law, you had 397 for oppression, 398 for mismanagement, and 399 equivalent to 244, giving the right requisite number for application. Right. So we have seen some practical problems. I'll assure you that almost all the problems asked in this topic come from 244. Okay, almost, with a few exceptions which combine 244 with something else, definition of oppression or mismanagement. So this has been the past. That's what I just thought I'll bring this to your attention. Right. Moving on, we have finished 241. We have finished 242. Now we are moving on to 242. We jumped into 244 only because it covered the topic of requisite number. Okay, because unless you know what the requisite number is, you will not be able to appreciate. So we went to 244. Now we are back to 242 and on track again. So even our institute material does that. You see, they cover 244 and then they come to 242. Now, 242 deals with the powers of tribunal. Once an application is pending under this section 241, the tribunal has certain powers. Okay, but first, before exercising the powers, 242.1 talks about the basic precondition. Right? An application is made under section 241 for oppression or mismanagement. Now the tribunal goes through the petition or the application, and the tribunal may be of the opinion that the company's affairs have been or are being. See, again they reinvent the wheel. God only knows why they do this. Because here they are confusing the issue. Because here they are using have been or are being. Because in which case, what about mismanagement, which deals with, it's likely that. So that is why they beautifully segregated the two sections. And in each section, you had a different approach. Okay. See, unless you know the old section, you will not understand how this whole concept has been messed up in the new law. Earlier, you had 397. Under 397, they dealt with oppression separately. 398, they dealt with mismanagement separately. And then they almost, this section was covered there. This 242.1 was part of 397 and 398 separately. Now they have taken those parts and put it in 242 subsection 1, which is why the confusion. Because for mismanagement, it is likely that, whereas here they are using the word have been or are being conducted in a manner. So the tribunal goes through the application. It forms the opinion that the affairs of the company have been or are being conducted in a manner prejudicial to public interest, prejudicial or oppressive to any member or members, or prejudicial to the interest of the company. So that they form the opinion. Okay. Then they also go on to form another opinion that to wind up the company would unfairly prejudice such member or members. But otherwise, the facts would justify the making of a winding up order on the grounds that it was just and equitable that the company should be wound up. Right? Now, this is a beautiful concept. You see, if the old 397 was there, you will understand it well. Because that dealt only with oppression. Okay. Now, in that section 397, they talked about oppression, and then they said, and that the affairs of the company are being conducted in a manner oppressive of any member or members, and that the oppression is of such a nature that The oppression is of such a nature that it is just and equitable that the company be wound up. Okay. But otherwise the facts would justify the making of a winding up order would unfairly prejudice the applicants themselves. See, so 397 was beautifully worded, but here they've combined the two and put it here. So what they're saying is whenever an application is there under 241, the tribunal should ask, is it better to wind up the company on the grounds that it is just and equitable to do so? If you remember your winding up portion, which is already covered, there are many grounds for compulsory winding up. One of the grounds for compulsory winding up is on the grounds that it is just and equitable so to do. Maybe you even saw certain case laws there. I don't know if you saw a case law called Abrahami versus Westbourne Art Galleries Limited. It's a nice case. Abrahami versus Westbourne Art Galleries Limited. It is a nice case law where, see, what happened was there was an art gallery wherein art items were sold by two gentlemen, Mr. Nasser and Mr. Abrahami. Things were going on well. Nasser possibly taking care of the showroom and Abrahami taking care of the purchasing, going around all over the world, buying antiques, and they sell. Maybe it was the other way. Nasser went around, Abrahami took care of the showroom. Either way, the problem started. They had 50-50 shareholding, good friends, life goes on. One fine morning, Nasser's son, NS, is admitted as a shareholder. Abrahami and Nasser each give up 1/4. See, they are having half, right? So they each give up 1/4. So that Nasser's son now gets half. With that, what happens? Abrahami's shareholding is reduced. Nasser and Nasser's son together now control more than 50% of the shares, which means Abrahami has become a minority. That is where Abrahami makes an application under the English law for just and equitable winding up under the grounds that it is. Abrahami goes for against oppression. Abrahami goes to the court and says, I am being oppressed by these two gentlemen, father and son. Do something about it. Give me relief. Which was similar to your petition under 241. But what that court did, they went through the case law. They went through the whole facts. They said, hey, Abrahami is being oppressed. No doubt about it. The affairs of the company are being conducted in a manner prejudicial or oppressive to Mr. Abrahami, a member. But it is just and equitable that the company be wound up. Okay? The facts justify the making of winding up order. Now, what happens is, in 242, the tribunal has to stop there and then say, to wind up the company would unfairly prejudice the members. How it will unfairly prejudice the members? Have you thought about it? Suppose the board of directors of the company have been mismanaging. They would have siphoned the funds of the company. They would have borrowed heavily from the banks. Profits would be siphoned out through unfair contracts to relatives, friends, etc., etc. Which means what would be left is only a shell with a lot of debt. Suppose insolvency proceedings or winding up proceedings are commenced, what will these people get? Nothing. So in a way, they would be playing into the hands of the majority. That is why in the next slide onwards, you will find 242 gives a lot of power to the tribunal to give relief to the members. Winding up is not the solution. Winding up will only create. But in the case of Abrahami and Nasser, the business was a going concern. There were a lot of assets. So the court said, look here, Mr. Abrahami, whatever we do, this is wrong. This is gone. Your friendship with Nasser is out. With the entrance of Nasser's son, you are no longer good friends. Even if you continue to be here, your life will be miserable. So better we wind up and you take the money and start your own business. So there they passed an order that the company should be wound up on the just and equitable grounds, which is why your Abrahami versus Westbourne Arts Gallery Limited case law is a winding up case law and not a oppression or mismanagement case law, though it has a link. Abrahami made his application under the equivalent of section 241 or the equivalent of section 397 for relief from oppression. He asked for relief from oppression, but the court says, hey, there's no point in giving you relief here. You don't continue. We wind up the company, take your share of the assets and start your own business. So they passed an order for winding up of the company on the grounds that it is just and equitable so to do. Okay, sir. But in this case, the tribunal forms, see how it happens now. Application is there, the tribunal goes through it, he forms an opinion that oppression is there or mismanagement is there in this case. Oppression or mismanagement is of such a degree that it is better that the company be wound up. But to wind up the company would unfairly prejudice the member or members themselves. Okay. Therefore, with a view to bringing to an end the matters complained of, with a view to bringing to an end the matters complained of, it may make such orders as it thinks fit. So this is the sum and substance of 242 subsection 1. Once upon a time, a very beautiful set of sections, now completely damaged beyond recognition by the draftsman of the new law. But what to do? It is my unfortunate duty to teach this part of the section, and I have done my best to decipher this peculiar section, because later on you will find problems occur again and again because of this unnecessary combination of two sections. See, the British lawmakers were not fools. When they passed the law, they knew what they were doing. This is not, this 397 and 398 were there even before independence. And the British knew what they were doing. I'm not trying to be colonial or trying to, say British are the best. I'm saying in this case, they did a good job. And so our friends, sitting in India with their limited knowledge of drafting have done this nonsense, and because of which there's a lot of confusion. But as of today, see, then I'm asking, why are you bringing this just and equitable and all? You didn't like the English. You didn't like the way the drafting was done. You wanted to have something simple, whatever, blah. Then make it simple. Don't bring this winding up thing itself, because winding up will be acceptable only for oppression. For mismanagement, there is no need for winding up, because 100% in case of mismanagement, if you wind up, definitely there will be a prejudice to the member. So winding up is not a solution. Whereas for oppression, in some cases, as in the case of Ebrami, it could be viable. Which is why at some point in time they might say, I'm not going to deal with this as an oppression petition anymore. I'm going to treat it as a winding up petition. And I will proceed to pass order for winding up. That power was there earlier under 402. That power is not there under the new 242. So I seriously don't know why they bring winding up into the picture and confuse the student further, or for that matter, the professional further. But still, I'm doing my best to cover this, to make your 242.1 somewhat clear. Right? You will notice that in our Institute Board of Studies material, the sections are given very clearly with some kind of support notes are also there, which is why I'm going a little more elaborate, so that when you read it, you will have some meaning of what is being mentioned there. Now, whatever may be, 241 application has been made, tribunal is appraised of it, tribunal is now saying, I will bring to an end the matters complained of. So it can make such order as it thinks. From now on, we are going to see a whole list of matters which may be provided for in the tribunal's order. In other words, 242 subsection 2 very clearly gives the scope of the tribunal's power. What all the tribunal can do to bring to an end the matters complained of, that is operation or mismanagement. So these are the powers of the tribunal in, shall we say, giving relief in cases of operation or mismanagement. So there are quite a lot of them. I'm going to go through them one by one. I have given the full body of the section in the bigger square, and in the smaller rectangle on top, you will find a brief summary is there for your easy remembrance. Regulation of conduct of the affairs. So fundamental. The regulation of conduct of affairs of the company in future. The regulation of conduct of the affair of, this is verbatim case section, not my words. The regulation of conduct of affairs of the company in future. Agreed. Now, regulation of conduct means they are fighting with each other. So how to bring this to an end? Hey, you do this, you do that. This is how we have to do. fixing some regulation. See, if you remember my domestic civil aviation case, where the first guy who came, the one of the promoters, he went on a petition to the tribunal under the old 397, 398. Now, in that case, the tribunal, the CLB then, the Committee Law Board, admitted his petition and passed an order in his favor. One of the first things in the order they passed was the management of the affairs of the company will go from Mr. X, who was the founder, to Mr. Y, who is holding 60% of the capital. And they also directed that the shares will be immediately allotted and he will become the shareholder of the number of shares he applied for. Automatically, he will become 60% shareholder. He now becomes the majority holder of the shares. And he was given the power to run the company. And they also said, you go now, you conduct 2 or 3 board meetings. They also suggested that they had a panel of experts. They also had a retired, senior official from Indian Airlines who was co-opted into the board as a director, advisory director, okay, and so on and so forth. And they held 2 or 3 board meetings. I was invited to each one of the board meetings because, as I told you, every time this guy comes, I'll have to go and be there. So it was there. So this is the first step, the regulation of conduct of affairs of the company in future, right? To give a simpler example, let us say that in a small classroom, 6th standard boys are there. Now with online, corona, online and all that, the old classrooms, I don't know when you're going to see, but some schools have started. And today when I was driving down to the office, I saw children coming out of a school where my old school, I saw them coming out of that school. So now they're sitting. Let us say that in the 6th standard classroom, the teacher is taking classes and there are 3 boys in the last row, one of whom name is Srikanth. I was always the last bencher, okay? See, last bencher getting rank, possibly I'm one of the few guys who did it, okay? I was never a good student in school. I always used to get bad marks till college. College was different. Madras University was useless. Anybody, even a blind fellow can get 80, 90 in Madras. If they don't, shame on them. Because the standard of Madras, any university in India for that matter is low. Okay, compared to that. So I was preparing full time for CA at that time. So for me, BCom was just evening college, going there, be with my friends, sit in the last row. Possibly when the professor was conducting college classes, I will be studying for my intermediate, by keeping the book and studying. In fact, there is even one classic incident when one of the professors was banking. He was conducting class on banking. It was a gallery style. I was sitting in the last row in the top, and I just was reading costing. He came near, saw what I was doing, said, "Sir, I'm studying costing for intermediate CA." Okay, thank you. He went off. Then he started talking his lecture. I told him, then I looked up and I said, "Sir, you are speaking so loud. I'm being disturbed. Please control your voice." Like that. This was the type of boy I was. So like that, 3 boys are sitting in the last row and fighting with each other, catching the collar and hitting each other and all. Now, immediately what the teacher will do first, come near them, beat them with the cane, and then tell, you go and Srikanth, you go and sit there in the corner. You go and sit there in the corner. The other fellows stay here. Basically, regulation of conduct of the affairs. So that if they are separated, at least the fighting will stop. So this is what the tribunal will do initially. Now the tribunal may, on the application of any party to the proceedings, make any interim order. See, after all, the final order will take easily a long time. In fact, that is why I gave you the example of my case law, where I said, in the case of this civil aviation company, they passed an interim order by which they made him MD of the company, and they told him to start conducting board meetings and report. So at the end of each board meeting, there will be a hearing before the tribunal where they will tell what were the contents of the board meeting, what decisions were taken, and all that. Okay. So they will pass interim orders for regulating the conduct of the company's affairs upon such terms and conditions as appear to it to be just and equitable. Having said that, that company could never be revived, and it went on for, finally it went into winding up. I don't know if any of you could even find out the name of that company, or any of you did it. Okay, so good. Next. See, this goes on and on. Two groups are there. Now, one group complained about the problem. So, making them manage the company is the first choice. But suppose the majority group, the stake is very high, whereas the minority, the stake is low, and they are not capable of managing the company. If they are not capable of managing, then what the tribunal will say, oh, okay, let the majority purchase the minority. Or either way, there is no rule that majority should purchase the minority. Minority can also purchase the majority. Whatever it is, the purchase of shares or interest of any members by other members or by the company. So in case both the groups say we don't have money, but both are agreed, the minority says I will go. Company has money, then subject to buyback of shares rules, the company itself can buy back the shares. Obviously, when there is a buyback of shares, there would be a reduction in the share capital, right? That reduction, where there's a purchase of a company by its, see, please note, I'm using the word buyback, possibly wrongly, because buyback is a very specific provision, 68 of the Companies Act, under special circumstances, up to 25% of the paid up capital and free reserves can be purchased. But here they're talking about purchase of shares. Normally, a company is prohibited from purchasing its own shares. A company is prohibited from purchasing its own shares unless the consequent reduction in share capital has been approved by the, in those days, court, then CLB, now tribunal. Okay. So whenever there is a purchase by a company of its own shares, then there will be a consequent reduction of capital. So in the case of purchase of its shares by the company, the consequent reduction of its share capital can also be approved. Now, this was a problem in those days, 90s, when there was no tribunal. Company law board was there, it had certain powers. The court was there. Power to grant, shall we say, power to recognize the reduction of capital was with the court. Now, whereas operation and mismanagement were transferred to the tribunal, there was a short period when there was a confusion. Now, the question arose whether reduction of capital needs the sanction of court, whether the tribunal had the power, and so on and so forth. Or, so now they have said very clearly the tribunal is appraised of both. So, while passing the order for purchase, it will also, shall we say, accept the reduction in capital or recognize the reduction in capital and note it. The consequent reduction of capital. In fact, reduction of capital, as you know, requires special resolution. In one case law, what happened? Jairam Dasgupta versus Cosmos Steel Limited. Very famous case. Jairam Dasgupta versus Cosmos Steel. COSMO, Cosmos Steel Limited. See, the tribunal, in those days, it was the court. Okay. When the case law was being heard, it was the court. There, the court very clearly passed an order saying the shareholders, one set of shareholders will purchase. There was a constant reduction of capital, and the board of directors took up the matter and they wanted the shareholders to approve the reduction of capital by passing a special resolution. The shareholders refused to pass a special resolution. Please understand, special resolution, the court may pass an order saying you pass, but they cannot force. It's very, very important for you to understand. Now, you can make an individual like Srikanth do something because he is one individual. If there is an order of specific performance, I have to jolly well perform it. If I do not perform it, I am guilty of contempt of court. But when the court is passing an order for reduction of capital and then the procedure of the section is special resolution, the members can see, you can make the members come to the meeting, you can make the members sit, you can give them the ballot paper, but finally how they vote, you cannot control. If you do, then it is not democracy. Sorry. Okay. That is not the way, at least the way I have understood democracy from my childhood. That is not the democracy. Okay. Where you tell him what to do. That is not democracy. Okay. So, which means what? The court's order can be made ridiculed by the members. That is why in Jairam Dasgupta versus Cosmos Steel, the Supreme Court very clearly said where an order is passed for operational and mismanagement, there is no need for passing special resolution for reduction of capital. The order of the court, CLB or tribunal, as the case may be, is final. That is further reinforced in the section where they give the power to the tribunal to condone the consequent reduction in share capital. Okay. Similarly, once they are apprised of operation of mismanagement, they can put a restriction or caveat on transfer or allotment of shares. Think about it. Further transfer or allotment can change the capital structure. So they will say, no, all transfers to be kept in abeyance till we decide what is to be done. Otherwise, what could happen is the directors or shareholders who are doing the malpractice could quietly sell or transfer their shares and go. Similarly, the majority group can allot further shares to itself and thereby dilute the minority. Of course, they can't do that because of another provision where rights issue, where if you want to allot shares, fresh shares, you should first offer the existing equity holders in proportion to their current holding. The minority cannot increase because of rights issue, but the minority can maintain its stake. The minority can actually maintain its stake. It can ensure that its percentage is not diluted because of rights issue. But if that is being violated, see, that is all part of the complaint. So they'll say no transfer. Similarly, there may be an agreement between the company and the MD or a director or manager, which may be unfair. Okay. So they say where it is not, it is not just and equitable, then they say the tribunal can set aside or modify any agreement between the company and the MD, any other director or manager, right? So this talks about three things: termination, setting aside, or modification. Termination is totally bringing it to an end. Setting aside, not permitting it to continue. Modification, changing the terms and conditions. See, termination or setting aside, I have no problem. You are saying that's the end of the contract. But modification, it's different. You are forcing me to do something. I am the other party to the contract. And you are asking me to do something which I did not contract. You say my contract is invalid. Okay, I will stop. But now you can't force me to supply at a price which I did not negotiate. You can't push the price on me. Something like that. That is why they have a special concept for termination. But before that, there could be termination, setting aside, or modification of any agreement between the company and any person. Here we are talking about MD, director, manager. Here any person other than those referred to in clause E, right? But think about it. Director, MD, a manager is one thing. This is a total stranger, guy who had nothing to do with this company. But except that he entered into a contract with the company. Now we are terminating, chalo, no problem. Setting aside, chalo, no problem. Modification, yeah. Okay. How can I undertake to do something which I never agreed to do? How can you force it on me? Again, in a democracy, this cannot happen. In a democracy, everybody has the right to do what they want. Okay. So that is why they give a clear indication that in case of a contract or agreement with any other person, such agreement shall be terminated, set aside, or modified only after giving due notice and after obtaining the consent of the party. Okay. Right? So, see here again, they have not read the old section at all. Termination, setting aside, it is enough in the old law. Termination, setting aside, it is enough if you give him notice. Because why should why should the tribunal get his consent, I say, for termination or setting aside? He will say no. He will say, I'm not giving consent. So it can be. But modification, his notice should be given and his consent should also be obtained. Because in modification, what you are doing, you are making him do something which he did not contract. Stopping is different. But no, shall we say, modification, you need to get his consent. But in the new law, so-called 2013 Act, all the three, termination, setting aside, and modification, you have to give notice and you have to get the consent of the party. Now think about it. You might say, you might ask, some of you might even be thinking, after all, this guy has come to teach me the subject for exam. Why is he so critical? Why is he commenting so much about the section? I'm doing it so that you will understand one important principle, that as a future chartered accountant, you have every right to comment about the law. You are an expert, or rather you will become an expert. And where you find that the law as passed in Parliament has a flaw, you are entitled to comment about it. You are entitled to say the law is wrong. You are entitled to write a detailed article clearly pointing out what it is. Right? Is the point. Good. So that is why I'm saying be critical of sections. It's not necessary that it is not as if these laws were passed. It is not as if God, appeared before Moses on Mount Sinai in the wilderness of Sinai and Mount Horeb in the wilderness of Sinai and gave these 10 commandments to him for him to come down and promulgate it. This is not 10 commandments. This is law passed by the people for the people. So we are the people and we are entitled to ask, why have you passed these laws? See, and there's no hidden agenda here, but definitely any law which is being passed, everybody who's affected has the right to object. And if that right to object is taken away from them, I say, where is democracy? Okay? I say, where is democracy? Right? So this is not democracy. So the right to object. I'm only, by criticizing this, I'm only reiterating my right to say that the law can be wrong. That Parliament can. Yes, I cannot comment about I cannot adversely comment about a judgment by the Supreme Court, because that would amount to contempt of courts. See, the judiciary has to be respected. And the judiciary, once they have laid down the law by a judgment, even there I can comment about the judgment. I can ask certain questions about the judgment. I can appeal against the judgment. But I cannot say the judge is a fool. I cannot say that, because that would amount to contempt of court, which is why, when we are writing an article and we are commenting about a judgment, and especially a recent judgment where the judge is still active on the bench, we would say the learned judge or the learned justice has possibly not considered. You cannot say he has not understood the law. You have to say the learned judge has possibly not considered the fact that so-and-so, so-and-so, so-and-so. Then you tell what the fact is. After all, law is what you and I decide what it's going to be. Law. It is not as if lawyers again have some sort of an esoteric, mysterious knowledge. It is the same law that they have to implement, and they could as well be wrong. Okay, judges could also be wrong. Otherwise, why should there be power for revision? Later on, when you come to tribunal powers of the tribunal, I will show you that the appellate tribunal has revisionary powers, which means that they can revise the orders passed by the NCLT. The NCLAT can revise the orders passed by the NCLT. So, I'm giving you all this information just to make you understand that you, as future members of my institute, of our institute, should be critical or analytical of any law. There is no need to accept a law merely because it is passed in Parliament. The law can be amended. In fact, Section 185, which we saw in an earlier session, was such a mess. And with the 185 as it was at the time of passing in Parliament, nobody could run a business. No company could function. No funds, financial management just came to a standstill. Okay. All the chambers of commerce, ASSOCHAM, everybody went and bombarded the then finance minister or the Ministry of Finance, because Ministry of Cabinet Affairs is just a sort of a dummy of the Ministry of Finance. So they went to the Ministry of Finance and said, Baba, what are you doing? It's going to cause grievous damage. So they amended it by amending the section, but as you know, by giving those exemption notifications. Then where they had no other go, they amended the section itself once. And that amended section is what we learned. Okay. So this is the point. So there is no need for you to think. So this is a problem here. The old law has logically put. Whereas here, suppose the court passes, the tribunal passes an order modifying, then it sends a letter to this guy asking for his consent. Guy refuses to give the consent. What will the tribunal do? I don't know. I don't have an answer for this. I hope the tribunal has. I hope the learned members of the parliament have an answer to my question. Suppose the other party to the contract refuses to give his consent, then it cannot be contempt because the section very clearly says you have to get his consent. Okay, so this is my humble view. I may not be wrong, but it's a view about the law. Okay. Now, some of you may ask me one more fundamental question. In the exam, what should I write? In the exam, you should write whatever nonsense is there in the section. Okay, that you have to, because only then you will be given marks. But as a future professional and as a potential intellectual, because I honestly believe that every member of my institute or our institute should be an intellectual. We are one among few. We are one among a billion, 2 lakh. We are 2.5 lakhs among 1 billion. Okay, we are special and we have to be intellectuals. We are the guardians of the intellectual capital of this country. Okay, we have to protect. Okay, if we become fools and chamchas of political masters, that is the end of everything. Okay, we cannot. We have to maintain our intellectual superiority and our intellectual distancing from this, or at least a few of our members should be willing to distance themselves from this type of nonsense and be aware and available to comment about any infringement of democratic rights. So, the setting aside of any transfer or delivery of goods, payment, execution or other act relating to property. Okay, let's take this very slowly. You have already gone through, you have already done winding up. You see the last 2 words of this slide. You'll see a word, fraudulent preference. Does it ring a bell? Did you study the same topic in winding up? Maybe you did. Because there also, when the tribunal is passing an order for winding up of a company, whether voluntarily or compulsorily, they can see if there is any fraudulent preference. Basically, what is fraudulent preference? Let us understand that. Then come in reverse order to understand this provision. In fraudulent, what happens in the case of an individual? An individual, Mr. X, let us say, was running a business. Okay, it was doing well, right? It was doing well, and he found that he did well, and he was also borrowing. He was borrowing from the bank, secured loan from the bank. He was also taking unsecured loans from his friends. So totally, the loans taken from the bank are secured on the building, right? Now he calls the amount is not sufficient, right? He's an individual running business, right? He has one asset. It is, let us say, it's not secured to the bank. It is available in case he does not repay the loan. The bank can sell that house because he is an individual. There is no limited liability. His personal asset can also be attached. So his beautiful bungalow in Tambaram or in some other place in the country, in Powai, wherever, okay, in Mulund, he has a 5-bedroom apartment in Mulund, whatever it is, okay, it's a beautiful place in Bombay where, yes, it is available, but the price of that apartment, maybe 30 crores, would not be sufficient to meet his the bank loan. He has also borrowed 7 crores from his friends, right? Now what he does, he calls his friends one evening for a party, and after serving Shivas Regal, all of them are in a good mood. He tells them, Baba, I'm going to file for insolvency. Immediately, whatever effect they had is gone. What are you telling? What are you saying? Then he said, don't worry, take one more large. Now I will tell you, this house is worth 30 crores. No problem. I have to pay the bank some X amount. Don't worry about that. I owe you guys 7 crores. I will settle it at 5 crores, right? You take the house. You give me 20 crores. Okay. So you actually have a nice margin there of 5 crores. You enjoy it. Do whatever you want. It is your problem now. I will register the house in your favor. After registering the house, I will file for insolvency. So when they come for selling my property, this won't be there. Okay. Now are you able to see this? What this fellow is doing is fraudulent, and he is also preferring some of his friends who are creditors as against the bank, which is also a creditor. So some creditors are being preferred over others, right? Now, in insolvency proceedings for an individual insolvency, not corporate insolvency, individual insolvency, if this is done and within 3 months from that date he files for insolvency, that would be the end of it. That transfer would be declared as invalid or void. The same concept is being introduced here. Okay, so the tribunal will see if there is any transfer, delivery of goods, payment, execution, which has been made or done within 3 months before the date of application. So there is a date of application. So they will go through the records of the company and ask if within 3 months before that date, have you made any transfer of property? Have you delivered any goods? Have you made any payment or execution? Whatever, which is done within 3 months before the date of application would be deemed to be void. And that will be set aside by the tribunal. Same thing in winding up, what you would have studied was fraudulent preference, that transfer, delivery of goods, etc. would be void. So whoever received it will not be able to retain it. He has to give it back to the company. So the due date for winding up fraudulent preference is 6 months. Okay. Here it is 3 months before the date of the application. 3 months. Okay. Right. So this is, I'm connecting this with your winding up provision. So in case the company has made any transfer, delivery of goods or payment, etc., within 3 months before the application under 241, then such a transfer would be set aside, or delivery of goods would be set aside. Do you also notice one more thing? They talk about under this section. This section is 242, but the application is made under 241. Okay, where is this section here? See, these are all loose drafting. Without understanding what they're doing, they're drafting. Okay, under this section, where is the application? Under 242, there is no application. It is the application is made under 241, right? But still, you can say 242(1) talks about an application. Therefore, you can say this section. But still, it would have been nice if they had talked about 241 rather than this section. Similarly, the tribunal has the power to remove managing director, manager, or any of the directors. Straight away remove. Okay. If any MD, manager, or director has made any undue gains, okay, during the period of his appointment, then that can be recovered. And how to utilize it also they can say. For example, if directors have fraudulently managed a company showing losses, not making losses. Please understand the difference. Genuinely making losses is different from showing losses. How they show losses? By siphoning funds through bogus bills and all that. So they take it out. Now we have discovered it. We can the tribunal can say, you have to refund it back to the company. Once the money comes back, then after all, the shareholders are the losers. Maybe because of this, there could be some sort of reduction in the share price. So they could say this is a loss to the investor, and they can say this. Any recovery will be transferred to the Investor Education and Protection Fund, or if we are able to identify victims, this money can be used to compensate the victim. For example, a shareholder buys the share. Subsequently, the siphoning starts. 2 years they do the siphoning, show losses. The price of the share plummets. The loss booked by the individual investor can be found out, and whatever the money has lost can be repaid to him. Can be repaid. This is some sort of a investor protection, as you could say. One of the 2 pillars of corporate law, investor protection, right? That way, if properly handled, tribunal has extremely good powers in case of oppression and mismanagement. They can really make a difference for the complainants. Okay. Sorry. I we saw. Now J. The manner in which the MD or manager may be appointed subsequent to an order removing the existing managing director or manager. So having removed MD or M, they can say how the new MD or M should be appointed. They can give clear criteria for qualification, for so many things, so that whoever comes in has to have all these qualifications. Also, in order to protect the interest of the company, they can appoint nominee directors. They can appoint such number of directors to, in the earlier law, it said to effectively safeguard the interest of the company. Here they use the word who may be required by the tribunal to report to the tribunal. So they will act as the watchdogs, eyes and ears of the tribunal. They will sit in the boardroom. They are appointed as directors. Technically, they come under the heading of nominee directors. If you remember your session on directors appointment, they will be technically coming under the head nominee director. They are nominated by the tribunal. They cannot be removed. They cannot be removed by the shareholders or anybody. Their job is to attend the board meeting and report as to how it happened, what were the problems still faced by the minority shareholders or whatever, whether the company's affairs are now on good footing, they'll comment. So they are the nominee directors. They are not independent directors. They are nominee directors, right? But they cannot be removed. But just to take up a point, nominee director, unless stated, they are you always use these words, no? You like to call them non-rotational directors, no? Okay, to use your own the way you use it, which I don't like. The nominee directors technically will not come under the not liable to retire category. They would be included for the purpose of calculating retirement by rotation. If you want, you can protect them. In the total number, they will be included. Once you calculate not less than 2/3, then the remaining number, the remaining who are not so liable, if you want, you can put this guy there. But technically, he will not be liable to retire by rotation unless it is clearly stated, as in the case of independent director and in the case of small shareholders director, very clearly stated that they will not retire by rotation. Here, I do not see that wording here. Okay, just my view. Maybe you might have a different view. I'm willing to listen to that. Okay. No, I wish they had included such a clause. It says, nominee directors appointed by some. Remember, the proportional representative guys also cannot be removed by the shareholders. Such a condition may be prescribed, is what I would feel. Okay. Or maybe I have a feeling the tribunal, while passing an order appointing these nominee directors, in that order they will put everything. They will say he cannot be removed, he is not liable to retire by rotation. Maybe that order, or they may direct the central government to pass an order clearly putting all this and appointing because tribunal actually may not appoint. They may ask the central government to appoint rather than directly appointing. Anyway. Finally, suppose there may be some situation where the applicants have incurred costs. After all, lawyers do not come cheap. So even for filing the petition before the tribunal for this would have cost money. So that cost, who has to pay? Usually the losing party has to pay the cost. So in this case, if an adverse order is passed against the company, then the company will have to meet the cost, or the erring directors will have to meet the cost. The directors who have been guilty of mismanagement or oppression, they will have to bear the cost. Finally, a kind of a residual clause where they say any other matter for which the opinion of the tribunal, it is just and equitable that provision should be made, right? Of course, this being a fairly straightforward theory, you might not have any doubts. So I don't find many questions in the query pad. Moving on to procedural part, 242. whenever a tribunal passes an order under section 241, a certified copy of the order shall be filed by the company with the registrar within 30 days of the order. This is the standard. Whenever an order is passed, it is the duty of the company to file it with the registrar within 30 days. See, in addition to restriction on transfer of shares, allotment, etc., tribunal can also say, alter your memorandum or articles to make provision. For example, when appraised of this matter, one of the things they can do, in the earlier law, they could do it in 402 was, they could direct the company to amend its articles so as to provide for appointment of directors on proportional representation. Do you remember when the tribunal is appraised of this matter, one of the things they can do is direct the company to amend its articles of association to provide for appointment of directors by proportional representation. So the company will amend its article. Now suppose 3 months later they again remove that clause. So no, the tribunal will say, where an alteration is made in the memorandum or articles, okay, notwithstanding any other provision in the act, the company shall not have power except to the extent, if any, permitted in the order, to make any alteration whatsoever which is inconsistent with the order, right? So when memorandum and articles are amended by order of the tribunal, they will stand amended. They cannot be re-amended or again amended by the company without the leave of the tribunal. That is something which is very important. You can see, if you still very badly want to amend something in that, some error has happened or some hardship is there, then you can request the tribunal to permit you and they can give you leave to do this. Okay. Otherwise, on your own motion, on the company's own motion, it cannot do. And in case any company contravenes this provision, there will be a punishment for the company of a fine of 1 lakh up to 25 lakhs. Not less than 1 lakh minimum, up to 25 lakh maximum. Officer who is in default, 25,000 minimum, 1 lakh maximum. It's a penalty for contravention of this offense. Suppose an alteration is made in the memorandum or articles, it will be as if it was made by the company in accordance with the provisions of this act. Again, alteration of memorandum and clauses of the memorandum and articles require special resolution. So they say no need. The minute tribunal amends the memorandum or articles, it will be having the same effect as if it was passed by the company in accordance with the provisions of this act. Okay. So wherever memorandum or articles has been amended, then or altered, then the company should file within 30 days after making the amendment or alteration, file the details with the registrar who shall register the same. So with that, the amended articles as amended by the tribunal will become the correct article. So any person visiting the MCA site will see the amended article or the amended memorandum as altered by the tribunal, order of the tribunal. Right. So this is as far as section 242 is concerned. Okay. We have finished 242. I know it's a bit too dry and we have had no problem oriented or thing like that, but this is how it is. So we move on to section 243, which deals with termination or modification of certain agreements. Okay. Now here you find that there are some important provisions where there is setting aside of order agreements. Okay. So you can look at two categories of agreements. One is agreement between the company and MD, director or manager. Agreement between the company, MD or MD, director or manager. Next is agreement between the company and any person other than these. Okay, E and F. In the case of E, the notice need not be given. It is enough if I simply send the tribunal says this is terminated or set aside or modified. Okay. But in the case of any person, termination, setting aside or modification will require service of due notice and obtaining the consent of the party. Okay. So this slight difference. Now in 243, we are going to talk about this situation where there is an alteration. Okay. So there can be only two alterations, right? Of course, you can also have setting aside of a transfer, but that is different. In terms of setting aside or transfer is there, but what we are looking at is termination, setting aside or modification of any agreement. So there are two provisions where this can happen. In both the cases, where the tribunal under section 242 terminates, sets aside or modifies an agreement. Okay, what could happen? Let us say, for example, there is a selling agent. That selling agent has been given certain terms which, according to the tribunal, are prejudicial to the interest of the company. For example, all other agents are paying 400 rupees for getting the product, whereas this guy alone is paying 300 rupees. That is, the selling price to this agent or through this dealer is 300, as against the other guys who are paying 400. Why is he getting a better price? Because he is the brother-in-law of the MD. Okay. So that means he is a related party. Okay. So they go through it and they find that it is unfair to the company. And so they may decide to terminate, set aside. Now, based on the agreement being in place, this guy, even though his intention was to defraud, because the MD of the company and his brother-in-law together have decided to siphon the funds, and the brother-in-law is used as an opportunity. How? He gets it at 300, so everybody gets it at 400. All of them have to sell at the MRP 750. So the difference profit 350 as against 250. That means 100 rupees per unit extra profit will go to the pocket of the brother-in-law, which is unfair. That 100 rupees into the number of quantities sold, every year they will share. The relatives will share. Obviously, the MD will get a kickback. All that money will accumulate. Right? So that is why we are having this whole issue. But suppose that agent who is appointed for selling the product in a particular district or a state or whatever it is, obviously he would have spent a lot of money, right, to set up the outlet, to provide space, rent would be paid, salaries, all this money is incurred. And you are suddenly saying, no, we are terminating it. The contract is for 5 years, whereas you're terminating it. Okay. Now they say, whenever you're doing this, the order of setting aside, etc., shall not give rise to any claim whatever against the company by any person. So what he does, he goes to his lawyer and he says, hey, this tribunal has done like this. What do I do? So the lawyer says, no problem. You have been terminated, good. But you have lost money, yeah? You got another 3 years of dealership running. Before that, they have terminated. Therefore, you claim compensation. The money which you would have earned if you had continued in office. The money which you would have earned if you had continued in office. If you have studied compensation for loss of office of directors, you will understand this. That is how the compensation is calculated, right? Suppose the director is in office for the remaining period, then whatever he would have earned would be the compensation, right? So they calculate it and they send them court. But then the tribunal says, look here, your termination was not by the company or directors. If the company or directors unilaterally terminates or sets aside or modifies your agreement, you have a case. Go to court. But the law very strictly says where it has been terminated, set aside or modified under section 242, then the other party is not entitled to claim any damages. or compensation for loss of office or in any other respect. Okay, either in pursuance of the agreement or otherwise. For example, even if the agreement does not talk about compensation, the common law principles may be there, where they can invoke common law and say, normally in this trade, the practice is to pay some sort of a compensation for loss of office. So, but in the case of agreements set aside, terminated or modified under 242, there is no question of damages or compensation for loss of office. The minute it is set aside, it means, or terminated, it means the other party is guilty. He has committed some kind of a fraud, though they may not take action. In fact, later on, I'll show that they can actually take action. Okay. But even if they cannot take action, right, they can still say no payment of any compensation for loss of office or damages for any loss. Okay. This is clearly enshrined in section 243. Now, we also saw termination or modification, or we also saw there may be an agreement between MD, director or manager. Agreement between company and any person, we saw no compensation payable. Now, this is an agreement even for MD, director, no compensation payable. Any contract or agreement, if it is including employment agreement with the MD, if it is set aside or terminated or modified, no compensation can be paid. For example, the modification can result in a loss. Even if it is a loss, he cannot claim any compensation for the loss. Okay. Now, another problem is there is an MD or director or manager who is having an agreement with the company. This agreement is set aside or terminated, then that person whose agreement has been terminated or set aside cannot be appointed, okay, as the managing director or other director or manager of the company. So this is a disqualification from being appointed or rather reappointed as a director of the company from which he has been, in which the agreement has been set aside. So to give an example, Mr. X is having an employment contract with XYZ Limited. Okay, he's an MD, he's also an employee. There is a clear employment contract between Mr. X and the company. Fair, unfair, very, very unfair contract. So the tribunal is apprised of the matter. Complaint has gone under 241. They go through the various documents, one of which is this agreement. They go through it and they see, given the qualification of the gentleman, given his capabilities, given his abilities, the salary is too high. It is not commensurate. So they might go ahead and say, we are going to set aside or terminate or modify. Whatever they do, once that order is passed, this man has to comply with that order. Now, when such an order has been passed, then that person whose agreement has been set aside, modified or terminated cannot be appointed as a managing director or manager or director of the company. Okay. So, see, his contract has been terminated. Therefore, he is out. Now, he cannot be also appointed in this company. Okay. Now, but then this disqualification is not a permanent disqualification. It is only for a period of 5 years from the date of the order, terminating or setting aside the agreement. Okay. Suppose you want to appoint him within 5 years, you want him definitely back, then you can apply to the tribunal, and with the leave of the tribunal, you can appoint him again. Right. So this is disqualification of MD, director or manager. Now, any person removed under section 242 cannot claim compensation. Now, if you remember, one of the powers was to declare a person to be not a fit and proper person, if you remember. Okay. Then, in that case, if you remember your 242, any person who is declared to be not a fit and proper person shall not hold the office of director or any other office connected with the conduct and management of affairs of the company, right? Of any company for a period of 5 years from the date of said decision. So where there is a declaration that he is not a fit and proper person, you can actually see. I think I'll cover it little later. Whenever there is a declaration by the tribunal that a person is not a fit and proper person, then it, see, if you remember under 241 subsection 3, you made a application to the tribunal to declare him as not a fit and proper person. I'll just take that 241 subsection 3 just to regain our point. Ah. 241 subsection 3 was a section where we found that in the opinion of the central government, there exist certain circumstances that, any person is guilty of misconduct, or he is not conducting in accordance with SBP or PCP, such and so on and so forth. If so, the central government can initiate a case, and based on that also 242 there can be an order. So because 242 is wide enough, 242 talks about any application under section 241, whether the application is made by the shareholders or whether it is made by the tribunal under 241(2), or whether it is made by the shareholder under 241(1), A and B. Ultimately, the tribunal has certain power, okay, and the tribunal will inquire into the case and record a decision whether he is a fit and proper person or not. Okay, now come to this point. Now come to the point where they say, where 243, they talk about a situation where any person is declared to be not a fit and proper person, then he shall not hold the office of a director or any other office connected with the conduct and management of the affairs of any company for a period of 5 years from the date. See, where there is a termination or setting aside of an agreement, he cannot be appointed in that company only, because here the word is the company. Okay, whereas where he is declared to be not a fit and proper person, he cannot be appointed in any company for a period of 5 years. So 242 and 243 both contain clear disqualification provisions. So in addition to the disqualifications we studied under 169, you also have additional. In fact, we studied that in disqualification. I don't know if you remember it. We studied 242. We spoke about 242 in disqualification, right? Now, so where a person has been declared to be not a fit and proper person, he cannot be appointed, or he is disqualified from being appointed as a managerial personnel in any other company for a period of 5 years. Now, if you want to appoint him before the expiry of 5 years, then you have to obtain the leave of the tribunal. Okay, so the tribunal may permit such person to hold such office before the expiry of the set period of 5 years, right? In case 243, 1 or 1A are violated, then the person who is knowingly a party to such contravention shall be punishable with fine, okay, or with imprisonment up to 6 months, or with fine which may extend to 5 lakh, or with both. So, for example, after he has been declared to be a fit and proper person, he should not act as a director. So, if you permit him to act as a director, then you are also equally guilty. So, the company will be the director who is knowingly a party to that contravention will be liable, punishable with imprisonment up to 6 months, or fine 5 lakhs up to 5 lakhs, or with both. So this is the section 243. Okay. So we already saw 244. We have to move on to 245. Now, as we are here, The time now is 7:25. So let us have a small break, say up to 7:35, when I'll again meet you and continue this discussion on operation and mismanagement. Okay. So a small break for 10 minutes. Hope to see you back at 7:35. well-deserved break. If you have any questions or anything you want to ask, feel free to put it up in the query board. Let me also make a point here. Today, we may have some buffer time. We may be having some time which is spare. We may not have a similar possibility in a future class. When I may be doing some other topic, I doubt if I'll have time. So in case you are going to ask any question, generally, nothing to do with operation or mismanagement, you are welcome to raise it in the query pad. In case you are online and you would like to get it clarified, put it up in the query pad. We may have some time at the end, some 10 to 15 minutes. We may have some time. I will definitely answer those queries also if you have relating to any topic taught by me in an earlier class. Appointment of directors, qualification, meetings, powers of directors. Also, what shall I say? Recently, whatever we have studied, operation, compromises and arrangements, operation and mismanagement. Any topic where you have a doubt, feel free to raise it in this session. Because I find that I may have some time in this case, right? Just as a matter of interest. Moving on with our session. We are now moving to a very nice and important section from the current exam point of view, because it is entirely new. For the first time in the Act, the Act introduces the concept of class action. Now, class action is a very, very powerful legal principle. There may be a group of people who are affected. They are affected as a group, not as individuals. Now, all of them may not have the time to file a suit. Okay? In which case, some of them can file again on behalf of all. That's why it's called class action. So there may be a class or group out of which a few are concerned and they file a suit. Now, any compensation paid in this case can be shared by all. This principle of class action is very important in consumer movement and in environmental protection. For example, when there is the famous, even today we talk about it. Almost, I think 40 years later, we talk about it. The Bhopal gas tragedy. And still the victims are there and still the compensation is being paid and yet to be paid and all. But the litigation against, shall we say, which company was that? I forget the company now, suddenly. The Bhopal gas tragedy, the case was filed by a few people on behalf of all. But the beneficiaries are all the victims. Everybody who was a victim of the Bhopal gas tragedy would be compensated. But the action was brought only by a few. This is called class action. But the person claiming it should be a person who is affected. So he should belong to that class. Then he can also join and claim the compensation. So this is called class action. Obviously, such a very, very wide concept cannot be brought into the Companies Act straight away. So they have brought in the form of section 245. Before we get into, I'm not covering 245.1 first. I'm taking about 245.3, the third subsection, because that talks about the requisite number of members, similar to your 244. In fact, even I'm using the same structure here. So that it's easier for you to relate. So here again, they talk about company having a share capital, company not having a share capital. Except that, here, under this section, members can make an application. Depositors can also make an application. So we'll be seeing the requisite number for members first. Then we will see the requisite number for depositors. So whenever members or depositors are apprehensive about the management of a company, they can prefer an application under this section. How many members are needed? A minimum number, right? Not less than 100 members or not less than 5% of the total number. Now, if you go through here, this is where, the new approach, the section does not contain any percentage. It says such number as may be prescribed, but it is prescribed in the NCLT rules. The tribunal rules prescribes the limit from where we have taken this. So the NCLT application rules, there they say this is the minimum number that is needed. It is there in that rules. Okay. So 100 members of the company or not less than 5% of the total number of its members, whichever is less, or members holding not less than 5% of the issued capital of an unlisted company and not less than 2% of the issued share capital of a listed company. So in the earlier 244, you had only 10% of the issued capital. Here they split it into two, one for unlisted company, another for listed company. For unlisted company, not less than 5% of the issued share capital. For a listed company, not less than 2% of the issued share capital. Actually, it's lowered. Even 2% can make an application because in the case of a listed company, the element of public interest is high. So they want to bring the threshold lower. But in the case of an unlisted company, the impact on public interest may not be high. So they say 5% of the issued capital. Similarly, as against 10%, which is there in 244, here it's 5% of the total number of its members, right? As far as company not having share capital is concerned, there is no change, not less than 1/5 of the total number of its members. Here also, the applicants should have paid all calls and other sums due on his or their shares, right? So please remember the requisite number calculation, very, very important. This is where you could be tested in the examination. So thorough knowledge of this one slide can make a difference of say 4 to 5 marks in the exam. This slide and 244, if you remember itself, it's enough. The rest of it you can manage. But these two slides, you should know well. 100 members or 1/5 of the total number of members, or in the case of unlisted company, 1/5 of the issued capital, or 5% of the issued capital. In the case of listed company, 2% of the issued capital, right? So here, as I told you, under 245, depositors can also make an application. So not less than 100 depositors of the company or not less than 5% of the total number of its depositors, whichever is less. So 100 depositors or 5% of the total number of depositors, or in value, in number we saw 100 or 5% of the total number. In value, depositor or depositors to whom the company owes 5% of total deposits of the company. So together, if you take the value of these guys, the applicants, the amount owed to them should be not less than 5% of the total deposits of the company. Okay, let me check up the section for 1 minute because I have my own doubt why they have not included. I'll just check up for 1 minute. As you can see on screen, I am referring to the BAR Act. I'm going to the chapter 16, 245, which deals with class action, 245 subsection 3, which gives the requisite number. See, the requisite number shall not be less than 100 or not less than such percentage, whichever is less, or any depositor to whom the company owes such percentage. No, my point here is, shouldn't they have said not less than such percentage? Not less than. Okay, I don't know. So the depositor or depositors to whom the company owes, I would say not less than 5%, because exactly 5% is very difficult, right, of the total deposits. It cannot be more, it cannot be less. The way you read this section, it says owes 5%. Such sum as may be prescribed. So exactly they should hold 5%. If they hold more than that also, they can't apply. If they hold less than that also, they cannot apply. Less than, of course, they cannot apply. More also, they cannot apply. Exactly, they should be 5%. That's how it can be interpreted. Okay, I don't know. So, but as of now, if you are asked in the examination, just check up if the guys are holding more than, not less than 5%. Okay, 5% or above, not less than 5%. Okay, so 5% or above. So this is the limit for depositors, and if the requisite number condition is satisfied, so the requisite number of members or depositors, first they should be of the opinion that the management or conduct of the affairs of the company, they should be of the opinion that the management or conduct of the affairs of the company are being conducted in a manner prejudicial to the interests of the company, its members, or its depositors. So slightly different from 241. So the management or conduct of the affairs of the company, right? I'm just removing this, are being conducted in a manner prejudicial to the interests of either the company or its members or its depositors. Which is why anywhere if there is a prejudice or detriment, or if it adversely affects the interest of the company, its members or its depositors, then such members or depositors who have formed the opinion may file an application before the tribunal on behalf of the members or depositors. So they are representative. They are filing on behalf of all the members or all the depositors for seeking all or any of the following orders. So you'll be seeing so many reliefs can be given, so many complaints can be made by the before the tribunal under this section 245. The orders which may be sought from the tribunal are there. What are all the matters for which the applicants can ask for? First, they can ask for an order. What are the orders which may be sought? First, an order to restrain the company from committing an act which is ultra vires the act or memorandum of the company. So please remember, if the act is intra vires the articles or memorandum, then the company can at any time ratify it. Ratification can happen at any time, or they can permit it. If it is going to happen in future, they can as well permit it by passing a resolution. Then no class action can be brought. Why? Because of the rule in force versus Arbotle. What the majority can ratify, no individual shareholder or even a group of shareholder cannot go and file unless they show mismanagement or oppression, in which case they should go under within the powers of the memorandum. If you want to file, you have to go to 241. If the act complained of is within the memorandum or articles, but it is oppressive or mismanagement, then your relief is not under 245. Your relief should be claimed under 241, 1A or 1B. It depends on which section you are going. But you have to go there, not here. But suppose they are doing something which is ultra vires the articles or memorandum, and see here, in which case even an individual shareholder can file, because the rule in force as Arbotle no longer applies, because this is something which is ultra vires the articles or memorandum. Therefore, they can take the 245 route also. Individually also you can file a suit if you want. But why? Because now the act is enabling you to file a petition to the tribunal where you can ask to restrain the company from committing an act which is ultra vires. For example, the memorandum of the articles of company may say the company cannot borrow in excess of 50 crores. They may put a monetary ceiling. They can do that because 181C talks only about borrowing in excess of paid up capital and free reserves, in which case they have to go to this company for special resolution. Here the articles itself may restrict it by amount and say you cannot borrow in excess of 50 crores. Then if they are trying to borrow beyond that, it is an act which is ultra vires. The articles are memorandum. So the class which is making an application can ask for an order to restrain the company from committing an act which is ultra vires, right? Similarly, to restrain the company from committing breach of any provision of the company's memorandum or articles. See, the memorandum or articles may provide for performance of something. For example, there may be a caveat in the article saying you have to do it in this way. So they are not doing it like that. Then it's a breach of the articles. So when they are trying to do that, they may be restrained. See here again, 245, though it uses the words are being conducted, has a kind of futuristic approach because it uses the words to restrain. Means they have not yet done it. You can get an order preventing them from doing it. So, suppose it has already been done. Memorandum or articles have been altered. Then a resolution altering the memorandum or articles may be declared as void, provided the resolution was passed by suppression of material facts or by misstatement to the members or depositors. Okay. So, where there is a resolution altering the memorandum which has been passed by the members without knowing the full facts. That is why, whenever you pass a special resolution, you have to give an explanatory statement. And that explanatory statement should contain all the material facts. Material facts, what is relevant, should be given there. Including the interest of any director or benefit accruing to any director or his relative because of this transaction. If that is not done and there is an alteration of memorandum or articles, then in suppression of material facts, then you can file under 245 for an order to declare the resolution to be void. To restrain the company and its directors from acting on such a resolution. Suppose they have amended the memorandum of articles. Okay. For example, maybe they are increasing the authorized capital to allot shares to the promoters, in violation of the articles. Okay. So they're amending the articles by which they are saying we can allot to ourselves without giving it to the existing shareholders. So such a resolution altering will be declared as void. And the company can be directed and restrained from not acting on such resolution. See, whenever there is a issue relating to minority or minority majority issue, you will also invariably find there will be an ego clash more than anything else. Money would be secondary. It will also be involved, but money would be secondary. The real issue would be ego. So, because in many cases, both of them may be big groups. So the MDs of the groups may be big shots. So it becomes an ego clash. You are me. And once that type of thing happens, it becomes a subject matter for the press. You'll find even the press is writing about it and giving their views also on what is to be done and stuff like that. The large listed companies, when they're having internal problems, definitely the issues will be talked about everywhere. For example, Apollo Tires had a problem where there was a suit within the family. So where again, the old section was used, 397 was used for relief. Like that, many companies go for this type of problem. And so it will become an ego issue. Okay, is the point. Once, in fact, I used to ask the company secretaries, in the Institute of Company Secretaries, I used to teach this subject. I started teaching law, company law, 1992. My first session was 1992 when I taught the old 372. That was my first ever class, 370, 372. That was my first section. So when I started teaching, and I used to ask them, what is the first thing you will do as a company secretary when a petition or application is filed with the tribunal under section 241? Suppose shareholders and then 397, yeah. Okay, I'm so sorry to keep on telling old, but I'm sounding like a Buddha. I am a Buddha, sounding like a Buddha also. So the point here is, so suppose there is a petition under 241, application under section 241 is filed by the requisite number of members. What is the first thing you will do as a company secretary? So they will give all sort of answers. They will say, I will do this, I will file that, because these guys, they can't be happy unless they file a form. So they'll be looking at what form to file, what form to file. They'll say, sir, come on, forget all that, yeah. Take out your CV, your curriculum vitae, whatever you call it, and you go through it thoroughly, add your current experience, update it. And if you are, nowadays, it's, in those days, when I used to conduct this lecture, I used to talk about CV and all. Today, I think I should talk more about, go to your LinkedIn website, go to your LinkedIn ID, go there and see your profile, see if it is up to date, and start doing something to float it around so that it will catch the eyesight of potential, hirers and HR managers, and be available for any time. Because the minute 241 petition goes to the tribunal, believe me, that company is gone. Infighting will happen and that company is gone. Question is, do you want to be employed in such a company is the point. Okay, I know I'm being very, very mercenary here. I'm being very, very, shall we say, callous, not careless. I'm being callous, C-A-L-L-O-U-S, callous. Because definitely, first you have to protect your own interest. Then only you have to protect her. In fact, sign of sickness of a company can be easily seen by who resigns. I'll tell you who will resign. The first guys to resign will be the marketing guys, because they have their ears on the ground. They know what's happening out there, the market talking about their company, and they know where the sales are coming or when it will come, when it will not come. So easily they'll know this company is going. Okay, so they'll be the first guys the rats will immediately abandon the ship. Straight, the rats will run first. They will jump, and they will see a nearby ship, they will jump there, and they will go and hide. Nothing wrong. I'm not saying it's unethical. I'm saying that's what they will do. That itself is a sign that these guys. Then who will leave? Our friends will leave. We will leave, because if you're smart, you will leave. Because if you're a smart guy, you will leave. You will use this opportunity when nobody knows about it to protect yourself and go out. Before the shit hits the fan, you are out. And then, of course, everybody else will go. That is nobody's problem, right? So maybe you might say all this is very unnecessary and callous, yes, mercenary, yes. But unfortunately, nobody else will tell you except a senior member of your own profession, right? And so be careful whenever, hopefully don't get employed in such a company. But if you are employed and then it becomes like this, then bad luck. So better you quickly jump. Otherwise, it's going to be deep shit for you or for the CFO or for anybody in finance to get a new job, because the color will always be there that you work there. Of course, if you're a different type of person who says, I will take up the challenge and I will support one of the groups who I think is fair and I will go through it with them, that is a good, laudable goal. If you have the maturity and the knowledge for doing it, and if the good trust is there between you and the group, then side with one of the, ideally, then what you should do, you should go with the majority group, not with the minority group. It's not about winning side, losing side. It's about correct procedure. Because remember, Foss versus Arbuckle, the majority shall have its way. The minority shall have its say. So better be with the majority, because the majority is the company. So your view should always be supporting the company view rather than any other view. This was told by a CFO to me when I asked him what is the basis on which a very, very powerful CFO, very highly knowledgeable member of our institute. We had a discussion in Kodaikanal where we were together recently when in the evening after dinner, we were going for a walk. When I asked him, he said, what would you have done? He told me, Srikanth, I will always side with the majority because they represent the company. And my loyalty is always with the company, is what he would say. So when I told him some story about whether in another company where there was a clash, he was giving this view. I think that's a very good opinion he's giving. It's a very good point we have to remember. So then orders which can be sought could be to restrain the company from doing an act which is contrary to the provisions of this act or any other law for the time being in force. When they're trying to do something illegal, like violating tax laws or evading tax, whatever. So they can get an order to restrain. This is very new and very, very fresh. I don't know how many applications have gone under this section 245. I'm sure the record is available publicly in the MCA website or in the Tribunal website, but 245 invoking, I doubt how many people have gone. Okay. Recently, in 2019, a company called Talvarkas, I don't know if you're aware, there's a company called Talvarkas. It's a listed company. Okay. I'm not revealing any secrets here when I discuss. This company is a very old company with a lot of, shall we say, background and a lot of. It's not an ordinary company. It was one of the first entrants in what is known as the gym and personal fitness business. So they set up a chain of gymnasiums, gyms, and training. Where physical fitness centers all over the country. It was a well-known brand. Maybe some of you might even have used the brand for your physical fitness during Corona. I think during Corona, they shut shop. Before that, Talvarkas used to be a good brand. But unfortunately, due to mismanagement and a wrong demerger, they went for a demerger because these guys, rightly or wrongly, they decided to get into what was known as a club business, health club. And that was loss-making. So they had to, that was bleeding. And the money from the cash cow, the gym business, was being pumped into the loss-making business. Nothing wrong in all that. But then they started siphoning funds. And now there is a forensic audit being ordered by SEBI into this company to find out if this company. So what I'm saying is this could also be a situation where they could invoke 245 and some of the shareholders could go for a class action. Okay, is what I would say against the promoters and management of the company. Because here again, there's a clear-cut point here that you can go. To restrain the company from taking action contrary to any resolution passed by the members. For this, you have to go to your intermediate syllabus. There you would have studied how before the AGM, members can propose a resolution, circulation of resolution of members. So any members can circulate resolution and they can direct the company to hold an EGM. If they request the company to hold an EGM, if the company does not hold an EGM, the members themselves can hold an EGM and pass the resolution. Again, go back to my fundamental principle. Who is the company? Majority of the members passing a resolution at a validly convened, constituted, conducted meeting. So if you hold on to that definition, then every section in the Companies Act will become clear to you. Who is the company? So that is why even those guys, without the directors calling, they can call the member. There was the old 169 where the requisitioning an EGM and passing a resolution there. They can pass. They can requisition, and at that requisitioned meeting, the members themselves may pass the resolution. Okay. So once they do that, they can also go to the tribunal and ask, we have passed the resolution. They cannot take action contrary to the resolution. Also, at the end of this XIC, especially in Talvarkar's case, the auditors also are equally guilty of fudging, at least for 2 years. That's why the forensic audit is going in there. And so in case there is any loss, financial loss, okay, or any other, shall we say, prejudicial act, so they can claim damages the applicants can claim damages or compensation or demand any other suitable action from or against the company or its directors. But you can't just like that go and use this section for doing civil action. If the depositors are having a problem, their deposits are not being repaid, there's a delay in repayment, they cannot use this section. Okay, they have got another section where they have to go, non-repayment of deposits, they have to petition the tribunal. But if the act is fraudulent, unlawful, or wrongful act, or omission or conduct, or any likely act or omission or conduct on its or on their part. Fraudulent, unlawful, or wrongful act or omission or conduct, or likely fraudulent, unlawful, or wrongful act or omission or conduct. You have to read that fraudulent, unlawful, or wrongful as common for both current act as well as future acts. Okay, so the damages can be claimed from the company or its directors. It can also be claimed from the auditor, including audit firm, for any improper or misleading statements made in his audit or its audit report, or for any fraudulent, unlawful, or wrongful act or conduct. Please note, auditor has audited, he has qualified, he has given a clear-cut disclosure in the notes on accounts. Thereafter, the members cannot simply go and say, the company, he has told very clearly, there is some mistake. Who told you not to read the balance sheet? If you have read this balance sheet, you would have been alerted. It is here that I have a complaint against the average Indian investor. The average Indian investor in the capital market, especially in shares, does not bother to read the balance sheets. Forget the numerical part of the balance sheet and P&L account. He will not even read the disclosures that we are giving. So much notes on accounts are there. Either they don't know or they don't care. I'm not joking. Many members of our institute also invest in the share market. They being qualified professionals, at least they should read the balance sheet, right, before investing. I find that they don't. They simply go by some news or some tips and they buy. And then later on, when the company does not perform well in the share market, the price drops, they say auditors are liable. They have not given the information. So, Baba, it was all there in the audit report. You could have seen it, because before investing, you should have done a proper valuation and a very, very, very thorough intrinsic valuation, clearly arriving at the intrinsic value using discounted cash flow method, and then decided whether the market is correctly pricing it or not, and then buy or whatever you want to do, instead of blindly rushing in at any price because somebody told you it's a good share, and then finding that the company share has dropped, and then saying, sometimes it could be, for example, Yes Bank is a classic example. There was a bank called Yes Bank. It's still there, very much there. It is very much there, but in the early, when it was formed, this Yes Bank was such a big hit in the stock market. Obviously, it was being, what shall I say, promoted. That is, the share price was being unnecessarily, with all SEBI, guidelines and controls and blah, blah, blah. This Yes Bank was fudging its accounts and doing all nonsense and getting its share price higher and higher. So people were blindly buying Yes Bank. Even when the first time when Yes Bank came in as one, it came in even as selected blue chip list and all, it came in some magazines. Okay. Whenever they used to come, I was the secretary of the Tamil Nadu Investor Association. I was the secretary, and as my duties as secretary, sometimes I used to address them also. And I used to give my views on investment and how you can manage your portfolio and stuff like that. And generally, the Tamil Nadu, the TIA, the audience and the general investing public in this country, they know everything. No, see, today in WhatsApp there is a meme which says, if a company has 100 crore turnover, they will get 100% tax rebate. I don't know who put up this meme, how it got circulated. It's a fraudulent thing, and it goes around. And many of our clients who are not, especially that sector, who are in the trading group and all that, who are into trading and all that, possibly not very well versed in English, these guys read this meme and then they come and call, sir, my turnover is 200 crore. Why am I not getting 100% tax rebate? He said, Baba, you cannot get it. It's a false. Then it's coming in WhatsApp, sir. That's exactly the point. It's coming in WhatsApp. So much news is there. These guys think they know everything. And so they say, sir, please buy Yes Bank. Yes Bank is a good share. Buy. From the dais holding the mic, I've told, don't buy Yes Bank. It's a dangerous company. I've read the balance sheet. I'm not happy with it. It's weak. I don't know to comment about the auditor, but don't take it. No, you are also a chartered accountant. I'm a chartered accountant, so I don't have to defend every chartered accountant in this country. What he does is his job. If you have any problem, file a suit against that auditor. See, now 245 gives the power to the members to claim damages or compensation from the auditor for any misleading statement. Subsequently, what happened? The whole fraud came out, and the Yes Bank shares plummeted. So many investors are affected. Of course, if they want, they can go under 245 and claim compensation from the auditor of the company. Personally, I am a member of the institute. I am also signing balance sheets, no doubt about it. But I don't have to defend every member here. Because one auditor signed wrong balance sheet in Satyam, every member of the institute cannot be put on the, shall we say, dock and accused. It's one guy. File a suit against him. Collect damages. Because don't blame whole profession because of one or two people, because of the one or two black sheep. Let them pay the cost of their. Because after all, why did they do it? Because they found huge wealth by doing such fraudulent acts, right? Let them now give back some of the fraudulently earned wealth back to the victims. So seriously, I have no sympathy with a fraudulent auditor or a fraudulent chartered accountant. No way. Because as a member of the institute who believes in honesty, integrity, and who has lived a life that way, okay, I feel that we should be the first people to catch them and put them into the thing, because it is in the interest of the profession to ensure that fraudulent, unlawful, or wrongful statements by auditors should be caught, so that we can expose them first, rather than the society exposing them and all of us getting lambasted because of that. This is my view. Of course, not necessarily the views of the Board of Studies or the Institute of Chartered Accountants, but I'm sure they will also agree with my view. There cannot be any other view that disciplinary action should be strictly taken on members who sign false balance sheets, who abet fraudulent activities. No way we can show mercy to them. Okay. So any expert or advisor or consultant or any other person. So see how they are given auditor special place, second item, then all other experts are coming. Any expert or advisor or consultant, and consultant is a loose word. Advisor or consultant is a loose word. It may be anybody. For any incorrect or misleading statement made to the company, or for any fraudulent, unlawful, or wrongful act or conduct. So all these people you can catch hold and you can get compensation from them. That's the point. Okay. Very powerful section 245. Nobody has even woken up to the fact that you can file a thing. Complaint. Now question. If you are not an LLP, if the firm of chartered accountants is a ordinary firm, non-LLP firm, where there is no limited liability, will the entire firm, will all the partners be liable? Okay, will all the partners be liable? This is something you have to be, very worried about, especially junior partners who possibly had no say, who had no role to play in this. Will they also become personally liable for the debt? So suppose he files a suit and the damages come to 3 crores or 4 crores, who will pay it? Okay. Which is one reason why all audit firms should take professional liability insurance, first of all. Okay, in case you are wrongfully sued, even if you are rightly sued, the insurance company has to bear. If you are asked to pay, the insurance company, but they will also have a clause which only protects civil liability. Where a fraud is discovered, then they may also wipe their hands and say, no, we are not liable for when you consciously committed a fraud. But where there is genuine negligence, and due to negligence, the action is being taken for gross negligence, then maybe they can say, okay, chalo, it is risk covered and we will take it. So who will be liable? Hold on. it will come in a later session, later slide. Okay. To seek any other remedy as the tribunal may deem fit. This is the broader residuary clause which is available, which is there with respect to all other type of, shall we say, actions which may be sought. Now, so I asked you the question, liability to pay damages. Where the members or depositors seek any damages or compensation or demand any other suitable action from or against an audit firm. So you're talking here about an auditor, including audit firm. So where it is an audit firm, obviously it is not one person. It's a whole firm. Then the liability is that of the firm plus every partner who was involved in making any improper or misleading statement in the audit report, or who acted in a fraudulent, unlawful, or wrongful manner. So that protects others. But then you have to prove your innocence. You should say, yeah, I was a partner, but I was not involved in that improper or misleading. Possibly not my audit at all. It was his audit. I never even know what happened. I didn't even see the working paper. I don't know what happened. Okay. What is fraudulent, unlawful, or wrongful manner? So though by the principles, but of course, if it is a limited liability partnership, you are safe because the liability of the partners of an LLP is limited. So LLP form is good, which is why many firms are getting into LLP and trying to convert. I'm also studying the possibility. I don't know whether it is good, bad, ugly. There are many issues to be considered, but then I think that's the way forward where we have to protect ourselves by converting into LLP is what I feel. Okay. Now, while considering an application under 245, what are the points to be taken into account by the tribunal? Okay. 1. Whether the member or a depositor is acting in good faith in making the application for seeking an order, or is his intention to create problem for the company, or is it a genuine concern about the manner in which the affairs of the company are being conducted? They will have to find out. Which is why, these 245 petitions, they may not pass an order overnight. They might ask the central government to make an investigation into the affairs of the company, and they may also call these people for an inquiry and ask, what are you, why, how do you know, how do you say this, and stuff like that. The tribunal can also consider any evidence before it as to the involvement of any person other than directors or officers on any of the matters provided in clause A to F, right? So whether it is only directors or officers, or are there somebody else, if in case you remember in your investigation subject, you might have studied investigation into the ownership of a company. The persons who are or have been financially interested in the success or failure, whether real or apparent. Old section 247, very powerful. The true persons who have been financially interested, not non-financially, financially interested in the success or failure, whether real or apparent, of the company. These are the real, people who are the owners of the company, because they may be using binamis, nominees. Shares may be held by binamis. Directors may be employee nominees. But these people are financially interested. If the company does well, they are happy. If the company does not do well, they are unhappy. The actual directors and shareholders, if you ask them, they say, "Chalo, what can we do?" Because it is not their money which is at stake. Okay. So this people are only using the nominees and binamis to sort of camouflage, and they sit behind them. So that can also be seen by the tribunal. Any person other than directors or officers. Okay. It's quite possible that such people could be there. Now, this is very important. Whether the cause of action is one which the member or depositor could pursue in his own right rather than through an order under this section. This goes back to your rule in Foss versus Harbottle. You can file a suit only if a corporate right is violated. If an individual right is violated, then individually you can file. Why are you coming as a class? But see, they are not saying you cannot come. They are asking whether they could pursue. Or is it that, only 3 shareholders are having a problem, but they are creating it as a class action? No. Then they'll say, hey, only you 3 guys have this problem. And you got a section there where you can go. Why are you coming here? Go there. Don't come to this. Don't come to 245 is the point. Where the number of shareholders is limited. Okay. And the rest of them are happy. You don't bother. See, class action is one where the entire class is affected, but a few people on their behalf are filing. But suppose only few people are affected, then why can't they explore their own remedy rather than through a class action order? Now, any evidence before it as to the views of the members or depositors who have no personal interest, direct or indirect, in the matter being proceeded. Okay, so they can ask. Other shareholders can be canvassed. They can be asked to give their opinion. Are you feeling that this is an issue? Do you think the time of the tribunal should be wasted in this matter, or is it better? Like, which is possibly why 245 actions are rare, because you have to go through this test, whether it is truly a class of shareholders which is affected, or is it only a few shareholders? Because if only few, then they have to explore their own remedies. Okay, but if it is a class, that is why they have prescribed 2%, 5%, and all that. But even if you satisfy the 2% or 5% condition and the application comes to the tribunal, still the tribunal can ask this question to the other shareholders, other members, other depositors. For example, there could be a delay in payment of interest on deposits due to genuine reason. For example, during Corona, there could have been a delay in payment of interest. Could be, in which case some members should not use this route to claim damages, compensation, vexatiously. Later on, we'll be seeing frivolous or vexatious petitions. So they cannot do that and irritate the company and try to make it this thing. Okay. Good. I think only Sumit Jain has given a lot of queries. Let me see. Thank you. Sumit, thank you. Union Carbide. Suddenly that name struck my mind. Bhopal tragedy was Union Carbide. I don't know how I missed that name. Union Carbide. It was the company that, had a gas leak due to negligence. It was a classic example of strict liability under the Environmental Protection Act. Anyway, continuing, there are a lot of good questions coming up. Let me take it all as a later stage. Okay, and yeah, I will take it up. Okay. Oh my God, only Sumit. I think I'm now getting a big doubt whether online only Sumit and I are here. Me speaking online and Sumit there. Even then it's good because I'm having a good student who is continuously interacting and asking questions. Others, if online, are welcome to raise queries and questions and, sort of be there. Today, there's a lot of time. You can, if you have questions in any other area, practical, for example, you went through the problem, you can even tell me which problem. I will put it up on the board and I'll put it up on the screen and we can discuss that. If you give me the topic, the page, the problem number or whatever, we can take it up. If at all, there's an opportunity we can't get again. This opportunity may not come later in my later sessions. I may be hard pressed for time. So that's what I am going to do. Anyway, Sumit says, please share some points to be taken care of while attempting the exam. Okay. And I may do that if I have some time. Yes, I will do that. To answer one more question, yes, Sumit, 500,000 people were exposed to methyl isocyanate gas in the Bhopal tragedy, MIC. Okay. And so this is something that we have to remember. And class means the group of same category of persons like creditors, banks, government. Yeah, but you are right. When you use the word class in its dictionary meaning, you mean a group of people having same characteristic. As you rightly pointed out, creditors are one class. Within that, trade creditors are one class. Banks are one class. Secured creditors are one class. Government as a creditor, public sector undertakings may become one class. It depends on how you classify yourself. But In this section, only two types are considered. One is member, the other is depositor. So these within members, you can have preference shareholders as a class or equity shareholders as a class. But depositors cannot be broken up into classes. They form one class. So on behalf of all the depositors, the requisite number can file. So in this section, you have to be careful. We are only talking about members and depositors. Okay. So that is it. Moving on. Whether the cause of action is one, we have seen that. We have also seen personal interest, etc. And where the cause of action is an act or omission that is yet to occur, because these people are apprehensive that the affairs of the company can be conducted. So if it is yet to occur, whether the act or omission could be, and in the circumstances would be likely to be authorized by the company before it occurs, or ratified by the company after it occurs. You see, borrowing in excess of paid up capital and free reserves without obtaining the special resolution is a violation of the section 181C, but it can always be ratified because it is within the powers of the company. It is ultra vires the board, but within the powers of the company. That is why we say anything which is intra vires the company, the rule in force versus our body will apply. That is what they are trying to do here. So whether the members can themselves authorize, if they authorize it or ratify it, then tribunal can do nothing about it because force versus our body will apply, unless it is an act of mismanagement or oppression, in which case 245 is not where you should come. You should have gone to 241. Okay, so that is the issue here. Where the cause of action is an act or omission that has already occurred, whether it could be or would likely to be ratified by the company. So where ratification by company is possible, tribunal will not interfere. Now, before we go into this topic, let me quickly, I have not put it up on a slide, but it is there in your institute study material. The fifth question in your institute study material. Let me try to see if I can have a view there. Full screen. I hope you can see this. I think this is better. I'll just remove this off and maybe page width I will try to. Yes. Yeah. So you're able to see the screen there. This is the Institute Board of Studies material I'm showing on the screen. There's a nice problem there. A group of members holding 380 lakh issued share capital of Zolo Limited, a listed public company, having total issued share capital of 15,000 lakhs as per latest financial statements, alleged that the company's board of directors is conducting an act which is ultra vires. Board of directors is conducting an act which is ultra vires the articles or memorandum of the company without altering the memorandum or articles. So they make an application to tribunal to restrain the company from doing such ultra vires act. Now, with reference to the provisions of Companies Act 2013, ascertain whether the application will be admitted. Okay, quickly, any of you give me your answer. Okay, difference between intra vires and ultra vires. Intra vires and ultra vires are Latin terms. Actually, the spelling given in the question is wrong. It is not like, unlike corona is a virus. This is not ultra virus. This is, as rightly spelled by Sumit in his question, it is VIRES. I think this is a typographical error, unfortunate typographical error, which can be rectified at a later in a later edition. But the point here is, what is ultra vires or intra vires? Ultra means beyond, intra means within, vires means power. VIRES is a Latin word which means power or ability. So ultra vires means beyond the power. Intra vires means within the power. So when they say the company from doing, see, you can actually see one thing. The word is spelled correctly earlier in the same question. Conducting an act which is ultra vires the articles. Ultra vires the articles or memorandum means beyond the scope of the articles or memorandum, or beyond the powers conferred on the board by the articles or memorandum. Okay, see, the board of directors, we already saw, has certain powers which are conferred by the act or by the articles or memorandum. Suppose the articles or memorandum do not give the power. Simple example. Suppose the articles say the company board of directors cannot borrow in excess of 50 crores and they want to borrow in excess of 50 crores. Their power is up to 50 crore, intra vires, within their power. If they borrow beyond 50 crores, it is ultra vires, beyond their power, which is ultra vires acts are void. Okay, that is the point. Any act which is ultra vires, the article or memorandum is void, ab initio is the point. Okay, having said that, these guys want to do something ultra vires. Now, this group of members, are they eligible to make the application? Anybody quickly? See, this question has a numerical part only. It's a pure numerical question. So, can they make an application or not? So, where is the answer? The answer is in 245 subsection 3, which gives the requisite number for application. So, what is the requisite number? They have not mentioned how many members are there. So, we do not know if it is 100 or 1/5 of the 5% of the total number of members. But they give you information about the issued capital. So, they say 380 lakhs of issued capital, where the company is having a total issued capital of 15,000 lakhs. So, if you calculate, see, this is a listed company. This is a listed company. So, for a listed company, the percentage is 2%. For the listed company, the percentage is 2%. We already saw this when we saw 245. If you can see this, company having share capital, members holding not less than 2% of the issued capital of a listed company, right? 2%. So if you calculate 2% of this 15,000, you will get 300. Since 380 lakh is more than 300, yes, application will be admitted. So Sumit also confirms it and the logic. Now, since we have some time, let me take you through this method. See, in the examination, in corporate law, in your paper, you will come across questions that are of three types. I've already made this point earlier. Let me again make it for you. Let me maybe use a PowerPoint to help me do this. Let me not, use my existing PowerPoint. Let me use a new one to show you what I mean, right? Okay, so there are three types of questions. In the exam, you have you can have three types. One, pure theory, or theory disguised as a problem. Lastly, pure problem. Now, the increasing trend is to have pure problem rather than pure theory. They are more into problem than theory. Pure problem questions are preferred. as against pure theory. In those days, once upon a time, you had a pure theory. What are the disqualifications? What are the grounds on which a person can be disqualified from being appointed as a director? Pure theory. You simply wrote the answer. Mug up and vomit. So memory was important. Today, memory is not important. Somebody who can remember content, all the content in the Board of Studies material, may not have an edge over a person who understands important part, but able to apply it to the question. So such a person will have more ability to get marks than a person who knows the entire content. Okay, and then he vomits it. No, because there in the exam, if he misses a small point, he's out. So pure theory questions, to my knowledge, no, not going to happen. But there could be a couple of questions that are worded as a problem, but finally, if you read the last line, the question would be theory. Advise the members on the procedure to be followed. So you can ignore all the story gups up and all. You can come to the fine point. Point is, what is the procedure for making an application under section 241? Something like that. There, you might have to write some theory. Again, my suggestion, as Sumit says, it's a lengthy paper. Believe me, paper length is defined by you. If you think you want to write pages and pages, it's your choice. Believe me, writing more does not get you more marks. You have to write what is relevant rather than you have to write what is relevant rather than what is, shall we say, whatever you know. Right? Even for a theory disguised as a problem question, write in points, which is why, the PowerPoint I have given you should be more than enough. I have done my best to summarize points. If you remember the points and you write it, you get mark. Believe me, gone are the days when a guy like me could write a thesis. So I used to write pages and pages in the exam. I used to argue this. I used to give learned quotations from Shakespeare and all in my examination papers. So no more. Okay, today they want crisp answer. Straight away, what is the answer? Content of the section. Maybe a couple of case laws if you know it. Welcome. If you know section number and you write it, welcome. See, they want to know if you know. Okay, so to an extent, believe me, knowledge of English actually is not important. What is important is appropriately identifying the section which is involved and writing, which means when you are writing a theory disguised as a problem, the first line that you should write is this situation is affected by, or this situation involves the application of which section. If you can write that, beautiful, because the examiner knows, wow, this guy has correctly identified, and then you go and write your answer. Okay. Now, pure problem, I'm now going to give you an approach. I'm going to put it up on the screen so that if you want, you have to take it down. Even if you're viewing this, because I'm not going to share it. It's like I'm writing on the board. Okay. I'm using the PowerPoint as a board. It's like I'm writing on the board. If I were in a physical class, I would write this on the board, blackboard or whiteboard, and you will copy it and go home. So that's exactly what you're going to do here if you are interested, because this is not part of my coverage. I'm giving it to you as an additional gyan. Okay, this is how I used to approach it. See, pure problem. When you are answering pure problem, there is a particular approach that you need to have. It's a 4-step answer. The answer should have 4 clear stages, right? Part 1. Represent the facts. I'm being very careful here. Represent. Don't repeat. Don't repeat what is there in the question. Represent it in such a way that you are able to apply the law. Right? So, for example, even in this particular case, if I'm answering this question, I would look at it and I will say, members, a group of members holding 380 lakh issued share capital in Zolo Limited, out of your total issued share capital of 15,000 lakhs, would like to make an application under section 245. They come, that's all, nothing else. Okay, once I say 245, the facts are clear. 380 lakh members holding 380 lakh shares out of 15,000 lakhs issued capital wish to make an application under section 245 or wish to make an application for class action. Okay, I don't know 245. You know class action? Write that. So that is one thing. Then part 2, where you write the law. Write the law. You are going to, suppose the question carries 5 marks, part 2 will get you 3 out of 5. Because even if you apply it wrongly, if you know the law and write the law, 3 lines or 4 lines you'll get. What you will write? Section 245 deals with class action. The requisite number of members should apply for getting relief under this section. In the case of members, the requisite number of members is, here if you want you can write 100 members, 5% of the total number of members, 5% in the case of unlisted company, 2% in the case of listed company. Right. For that you will get 3 marks. Then, and that will not take you much time. Believe me. Part 3, very important. Apply the law to the fact. Okay. Means from the facts given, it can be seen that the number of members making the application is 2% of the issued capital. If you want, you can put 380 by 15,000 into 100 equal to 380. Okay. So you calculate 2% and you say, since the number of members making the application is 380, which is more than 2% of the issued capital, they are entitled to make the application. Okay, you see the question once more. Ascertain whether the application will be admitted. So in applying the law to the fact, you say they are entitled to make the application. The matter regarding restraining the company from doing an act which is ultra vires the articles of memorandum is a ground for which the tribunal can pass an order under section 245. Finally, once you have done this, you have to go for the last part, which is part 4. Okay. Friends, don't write part 1, part 2, part 3 in the exam. This is given to give you a clarity. Give a paragraph cut. After you represent the facts, cut the line. Next paragraph, write the law. Cut the line. Next paragraph, apply the law to the fact. Finally, conclusion. Conclusion is a single line. It is the answer to the question, which should be, therefore, the application will be admitted by tribunal NCLT. Separate line. Because an examiner in his hurry is looking at the last point. He has got the right answer. Good. Let me see what he says. He goes back into or let me see what she says. Because it could be Anjali also. So if so, who is writing? So let me see. And then they will, if you are able to use this 4-step method, then believe me, I mean, that's all. The guy talking to you has done it 100 times and he has successfully done it. If you accept it, it will be great. Okay. Before I go back to the subject, one more point. When you are getting the question paper, don't rush to answer. There is time, 3 hours. 10 minutes is allotted for reading. Have a pencil in your hand. Read the entire paper thoroughly once, not in depth, but as you read the question, you will know whether you know it, whether you are aware of it well. Is it a question that you know? So start grading the questions. So when you see a question that you know well, give it A. When you see a question that you know reasonably well, B. When you see a question whose ugly face, oh my God, then give it C. Grade it first, so that you know which ones you know well, you know which ones you don't know at all, and you know which ones you can manage. Now, first question you should write should be the one which you know well. Top question. You should know it. Then you should write that first. maybe even the second question should be a category question. Thereafter, stop A categories. Because you can't always, there may not be so many A categories. Unless you are well prepared and you are highly knowledgeable in the subject, then almost 60% of it will be A category for you. Wow. But even if you aren't that good at studies like me, no problem. You'll have at least 2 or 3 A category questions. I will write first only the A category 2 questions. Then I will go for the compulsory question. Usually there will be a compulsory question. And that will be tough and that will be hard nut to crack. I will answer the compulsory question as the third, which I have to anyway answer. I cannot get away from it. And I will put it there. I'll give some 1-page buffer gap so I can come back and add to it if I want. Then I will go for another A question and then B questions. And finally, the C, okay, which I don't know also sometimes. But because I don't know a question, I will not avoid writing an answer. If you leave out a question, my dear friends, you will not get any marks. Whereas if you write one paragraph, brother, you will get 1 mark, 2 marks. That matters for me, sir. For me, it's a big thing. In fact, in the ACS exam, there was in final indirect tax. Okay, I'm going to retrieve it on a secret. I did not study customs at all. I just went through the side answers because I just couldn't understand this bloody topic. Yeah, customs. It was in Tamil, we use the word custom. It was custom for me. So I could not. But whereas, excise, I was thorough. CST, in those days, I was thorough. Central excise, wow, I like the law. I remembered it. This custom was custom. So I said, let's leave it. I read only the important, in the side, that is where institute is giving you practice manual. What more can an institute do? They're giving you practice manual. Today, thanks to the Board of Studies chairman and the great people who are there, our institute Board of Studies is your practice manual. All the questions are included here with the answer, which is fantastic. Your preparation, you need not go beyond the Board of Studies material, according to me. No need for textbooks. Your BOS material is more than enough. So once you do that, you know what are the important areas. So for customs, I did only that. I didn't read the entire study material. I read only the side answers so that any oft repeated question, I will remember it. I went to the exam hall. I wrote central exercise, the same A category, then compulsory question, which was in CST. Then one customer was there. Just I write 1-2 lines and I kept it. Then B category. Then finally, one custom question I have to answer, right? It was on rebates in customs. Rebates under the Customs Act. Luckily, I had seen its ugly face, but still it's not clear. I wrote 5 lines. Customs Act, rebates are provided. Rebates are provided for imports which are necessary for the country. Whenever an importer wants to import a necessary item, rebate will be something, yeah. Okay, I'm sure the exam, remember, the examiner has already seen your A category performance. He is impressed. He has formed a favorable opinion about you. And now suddenly, his psychology is such, he will not want to change the opinion. So he will say, chalo bhaiya. It's a poor fellow, let us give him. So he is already so liberal in his marks earlier, the trend will continue for the last question also. And he will give you another 2 marks. Or 2 marks is enough, ma, for this question, where if you have not written it, 0, ma. So I think 2 marks is a great possibility. Boss, this is how I got all my 4 ranks. It's like a planned game, yeah. It's like a match that I plan and play, like a tennis match. It's not a casual thing. Just I go there and start swinging the bat. I plan every move. I plan everything that I do in that exam hall because those 3 hours are going to make a difference in my life. Yes, definitely for me. I don't know about you. For me, it made a difference. Whether my father will respect me as a human being or not. That was at stake there. If I failed, that is it. My father will never respect me again. So I had to write that exam. I had to pass that exam. Rank was something. I had to pass that exam. That was writing in that exam for me. Forget money. Money comes later. Okay. I'm just letting you in on an important secret in my life. Because my father was also a chartered accountant. And he had clearly told, Srikanth, you cannot become a chartered accountant. Because you don't have the brains for it. And I had to prove to him that I had. See, that was what was at stake for me. Every exam that I went into the hall, I had to prove to myself and to my father that I am capable of becoming a member of this institute. And so that is why I used all these techniques. I can't afford to be casual in my approach here. So, and again, I am not an intelligent man born like Einstein or so on. So I am an ordinary human being with a limited brain. So given that, I needed to work like this and I needed to do what I did. And I'm suggesting that you should also follow this. I'll assure you that you will get. I mean, in many subjects, I got more than 60. In some subjects, I got 50. In 1 or 2 subjects, I got 45. Okay. So I know I'm not brilliant. I'm not saying I'm brilliant like some people. I'm an ordinary person. But because I got 60 in 3 subjects, 50 in some, 40 in 3, I got a rank. All India 27th rank in final, All India 30th rank in intermediate. Chalo, rank is secondary, okay, is what I am trying to say. In ACS, I got All India 4th, and in the final exam of ACS, I got All India 10th. So all I'm trying to say, my dear friends, since Mr. Sumit wanted me to give this approach, I thought I could share this stuff with you, and I hope he is happy. Okay, so even if only one person hears this and applies it, it is good for me. Okay, this is like bonus for you. Okay, I have not covered this. I have not given this inputs in any other session in the BOS virtual coaching classes, but this is for you, whoever is listening. Enjoy and write the exam well. Become a member. Okay, remember, who is standing between you and becoming a member of the institute? Not the president of the institute, not the board of studies, not the council members. It is if 7 people, 7 examiners, they are standing between you and becoming a member. Impress them. Prove to them that you are capable of getting into the institute. You are a member. Remember that. 3 valuable hours. Don't waste it when you are inside the exam hall. My humble request to all of you. Okay. So going quickly fast, we got public notice shall be served. Okay. And when all similar applications are there, they'll be consolidated into single application. Okay. And then the first guy, the lead applicant, will be selected. And then whatever order he gets will be for everybody. 2 class for the applications for the same cause of action shall not be allowed. Everything should be consolidated into one. Okay. The final cost or expenses will be defrayed by the company or any other person responsible for any oppressive act. Any order passed by the tribunal shall be binding on the company and all its members, the depositors and auditor. Okay, so once the class action is successful and the order is passed by the tribunal, it will be nobody else can go against it. It is binding. Okay, of course, within the framework of the NCLT rules. Remember, later on we'll be discussing appeal against the orders of the NCLT. So appeal is possible, but nobody can say, I will not obey the tribunal's order. It will be binding. If they have any problem, they can go on appeal within the framework of the NCLT rules. If they lose the appeal, then they have to jolly well come back and obey what the order says. Okay. Even though it is obtained by a few members, it will be binding on the company, all its members, depositors, and auditor. In case there is any contravention of section 245, fine on the company. Means if the company does not comply with the order of the tribunal, then a fine of 5 lakhs up to 25 lakhs. Any officer in default, imprisonment for a term which may extend to 3 years, or fine which shall not be less than 25,000 but which may extend to rupees 1 lakh. Right? Now, lastly, suppose somebody takes a frivolous or vexatious application, then the tribunal can take action against him. For example, the tribunal can shall first of all record that in writing, then it will reject the application and finally make an order that the applicant shall pay to the opposite party, that is the company or the director or the auditor, a sum of 1 lakh as may be specified in the order. Believe me, suppose the auditor is a very honorable man and he has given proper disclosures and all, he can hire an advocate, appear before the tribunal and say that it is frivolous and vexatious and say, I am eligible for damages. That is also possible, provided the auditor is able to prove. And for that, your auditing paper, you have to remember, your audit documentation should be spotless. Your audit working paper should be spotless. When you stand before the tribunal, what will speak is not your words, but your audit working papers. Did you ask the questions? Did you get the answers? Did you record it? How did you record it? Are there email correspondence? Is it there in your file? Can you produce it? Or is it all simply that you told him something? No, you should have put it, there is a violation of section so and so of the act. You should not do this. And thereafter they should have done it. Then in the accounts you have qualified it. Then you have no problem at all. You can say that it's a vexatious or frivolous, and you can ask for damages, right? 245 will not apply to a banking company for two reasons. One, banking company is governed by its own law. Two, such action against the banking company could give a, shall we say, false opinion about its stability, and that should not be done. Therefore, the Act exempts this section for banking company. Try to remember that. Okay. So this once this section is complied, an action may be taken into this section by any person, group of persons representing the persons affected. That is why it's called a class action. It need not be taken by all. It can be done by one who is affected, provided they comply with the provisions of this section. Right? There is a last section 246, which sort of says 337, 338, 339, and 340, 341 of the Companies Act will apply mutatis mutandis with such changes to this chapter also, chapter 16 also, right? Now, these sections, 337 to 341 deal with various penalties for offenses committed by the contributory or officers at the time of winding up. See, the tribunal, when it is apprised of a winding up petition, may find that some offenses have been committed by contributories. For that, there are penalties under these sections, right? The same penalties will apply for offenses which are discovered when a petition is made or application is made under 241 or 245. So at the end of the 241 or 245 matter, if the tribunal finds these offenses have been committed, then the penalties can be invoked. They have the right to invoke 337, 338, mutatis mutandis, with such changes as may be needed. So basically 337 is a penalty for fraud by officers, 338 liability where proper accounts are not kept, 339 is a liability for fraudulent conduct of business, 340 damages to be claimed against delinquent directors, 341 deals with the partners of directors are also liable, and so on. These sections are covered in winding up. Therefore, I'm sure you've studied them, and from the exam perspective, I don't really see them as very, very important. So we have come to an end of oppression and mismanagement. So your oppression by me also comes to an end with this, and we move on in the next session on 22nd to miscellaneous topics. Okay, when we come there, we'll discuss that. Today, I had the opportunity of discussing some approaches with regard to the examination. They are given with a tongue-in-cheek. This is the way I do it. I'm sure there are better methods, other methods, but my humble suggestion is you can do like this. Okay. Thank you very much. And I wish you all the very, very best, and hope to interact with you again in the sessions, and hope to also meet you in person. Till then, good night. See you.